What happens when police charge a passenger for simply being in the wrong car? Today's courtroom moment left even the judge completely stunned.
Good morning, Mr. Sarmiento.
Ese es señor Sarmiento.
You were,
Bien, señor Sarmiento.
Buenos días.
you were charged with criminal trespass. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney appointed if you cannot afford one.
Si no puede ocupar una.
Yes, Judge.
I'm going to go slow.
Yes, Judge.
Más escuchen.
On January 5th, 2025, the officer became aware of a stolen vehicle via a flock alert. The flock alert was for a listed stolen blue Hyundai. The officer checked the vehicle's license plate and observed the vehicle stolen as of December 21st, 2024. The officer observed the vehicle turning northbound onto East Tex Freeway, taking the ramp heading north on East Tex Freeway, and ran the license plate, confirming the vehicle to be stolen. A traffic stop was initiated. The officer announced themselves as HPD while giving command to turn off the vehicle and place hands out of the vehicle. The defendant, the front passenger, was the last to exit the vehicle, and the officer made contact with the complainant, and the complainant stated he did not know the defendant, did not give the defendant authorization to operate the vehicle.
What?
So they found the stolen vehicle, Your Honor.
How does he know that it was stolen?
And Your Honor, there's no need for him to know this vehicle. There's no requirement he knows, only that he's in the vehicle without permission from the owner. And the owner said he does not have.
How does he even know that the person driving stole the car?
Well, he doesn't know the defendant. He doesn't know, he didn't say he know he stole it. He just didn't know him, did not give
So
permission.
you're telling me that he's in a car, he doesn't know the driver, and
Right, the complainant just said that in regard, he did not know the defendant, did not give.
I understand that, I get that,
Yes.
but, so he's, he's a passenger in the car, and they charge him with criminal trespass. And in the DIMS, it says that he doesn't even know the driver. So how would he even know that the car is stolen? How do they know each other? I'm beside myself. I don't. When a criminal trespass requires some kind of like notice that, hey, man, you know,
So the trespass was the driver driving into the area and he was the defendant.
he's the passenger, right? I would assume that the driver got charged with UUMV.
Let me see what he got charged with.
If you tell me no, I'm gonna lose it. Really?
Yes, Judge, UMB.
Okay. But the problem is that like, how would he know that the car is stolen? Right? You got to give me something that it's a specific intent crime. You have to, you know, there's got to, in my opinion, you've got to somehow know that the car is stolen. And
Your Honor, further, I guess to get to that, he was in a relationship with the defendant who was in the vehicle, and there were signs of damage to the vehicle that the officer articulated, saying that there was, one moment,
a scratch on the hood.
signs of theft that would lead a reasonable and prudent person to believe the vehicle was stolen, as the steering column was broken in a manner that only a screwdriver could turn the vehicle on, and the screwdriver was tagged into the evidence. So there was damage from a screwdriver in the vehicle indicating that it was stolen, and this defendant was in a relationship with the driver of the vehicle. And then furthermore.
Did you just tell me that they didn't know each other?
No, the complainant does not know the defendant.
Oh, okay. But I thought you also said that the driver and
No, Your Honor, and it may be misunderstanding because of me, but it's the complainant saying he does not know this defendant and did not give permission to the defendant to operate the vehicle.
so there's enough there that a reasonable person would believe
That the,
he's in a stolen car.
Stolen, yes.
So the steering column, was it?
was broken, and the officer said that in a manner
Esa
only a
era que
screwdriver could turn the vehicle
pensé que
on.
nomás un desarmador podía apagar el vehículo.
See, I don't know, because when I was young and dumb and 17, and, my friend had a CJ7, you ever been in those Jeeps that are just jalopy Jeeps, right?
Yes,
They
Judge.
always broke down. They always had a problem. We always, Jimmy rigged it as well,
In this case, Judge, I believe there would be enough for PC because we have a vehicle with evidence of breaking into the vehicle with that damaged steering column.
I've been in vehicles like that before.
And we furthermore have a complainant saying he doesn't know the defendant in the vehicle.
No difference.
That goes to the element of without, for the criminal trespass, it goes to the, with, knowledge that it was,
Nah, no, I'm sorry. I'm gonna find no probable cause. I'm sorry.
Que no hay razón probatoria.
Be careful. When you hang with dogs, you get fleas. I don't know what your status is in this world, if you're in this country with permission. But if you go to jail and you're not in this country with permission and you spend any kind of 4+ hours in there, immigration will put a detainer on you and you will be stuck like Chuck in there until you get shipped to immigration. So live like a halo, especially if you're not well documented in this country. Go ahead, take a seat for me, sir. Mr. Johnson, you were charged with burglary of a motor vehicle. You were facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
yes, Judge. On September 22nd, 2023, officers were dispatched to a lawn management company at 630 Rankin Circle for a burglary in progress. The defendant and a co-defendant had cut through the fence surrounding the property and were searching through vehicles at the location. There were surveillance videos of the defendant and co-defendant inside a van on the property.
Can you run an NCIC on him? I'd like to know what, if anything, has happened from the time that he picked this case up to the time he's now back in front of us.
Yes, Judge.
I don't know, Mr. D. Guys, he has a warrant for now, and I don't know if I'm gonna give him a PR bond. I want to see how he's been since September 23. If you've been on picking up cases like it's just left and right, then I don't know, man, but
Yes, sir, Your Honor.
my only concern is my community. That's all I care about, and I'm going to do everything in my power to protect my community. If you've just become a danger where you're hopscotching states and you're playing hopscotch and you're picking up cases while you're hopscotching, no. The revolving door closes.
So I do see on December 7th, 2023, the Georgia case theft by taking, but that's the only other case.
Is that a felony or was that a misdemeanor?
It's felony, Your Honor.
What was it? Do you have a disposition?
No, there's no disposition listed.
13 months per him, Judge.
Anything else he's picked up?
No, Your Honor.
I have the, oh man, sweet. All right, let's see.
I'm going to reinstate your bond now, but I'm not going to do it again. If you take flight on me again, I'm telling you, I'm going to make it high. No more PR bonds for you. You got a little kid in your charge, man. Be the good father that you should be. Teach them right, because they look on you for support and for them to do the right way. They see this. We don't need more. Know what I mean? Come on, man. Be better. I'm placing bond conditions on you now that you're not to go back to this location where this occurred and you're not to be in possession of weapons.
So,
Don't pick up any new cases. You've got a great lawyer here. Just listen to him. He'll take care of you. If I find that you're becoming a danger, you know what's going to happen. I don't have any tolerance. We have nothing but death and destruction on the news. I don't want any more. Do you understand? So, all right, man. Good luck. Don't leave until you sign the bond conditions. Okay.
Thank you.
That states bond condition?
Yeah.
Your Honor, can you hear me, sir?
I can hear you. And let me tell you now that I really haven't seen a lawyer go above and beyond the call of duty as Bayoshi has done in this case. Everything and every time you have been back here is because of something that has happened, or I'm sorry, something that has failed to happen. The last time here, all you had to do was provide documentation that you could not afford whatever it was. You have failed to provide that documentation. As a result, they've now kicked you out of the program. I know that Bioshi is going to give it one last shot as to whether he's able to either get the case dismissed, get you back in. I don't know. But I am now putting this baby to bed. So I will give you a week. Is that okay?
Yes, Your Honor. That should be enough time.
I am not waiving your appearance anymore. And in the next week, if he is unable to get you back into the program, if he is unable to get the case dismissed, you must either accept the plea bargain agreement from the state, or I will immediately set your case for trial, and it's going to be a very short trial setting. Do you understand?
I understand, sir.
It's unacceptable that we are now at 800 days, and they have literally over and over and over bent over backwards to help you. And if I were you, I would probably just, I can tell you now that Bioshi's not very happy with you as well.
I'm not happy with myself too. And
So-
I don't have power over the old situation.
I don't want you to say anything. Don't say anything. There's nothing you need to say. The only thing that matters are actions. You telling us something it goes in one ear, it goes out the other ear. Because when you get out there, we still have issues. So I don't care. I'm giving Bioshi a week to do what he can do. If it doesn't work out and it doesn't end up getting dismissed, you must be here in court. If you fail to appear, I'm going to revoke your bond. Do you understand?
I understand, sir.
Thank you, Your Honor.
Hold on. Before
Thank you, Your
leaves,
Honor.
I want to give him the date.
Oh, yep, you need to.
Don't go, because I want to give you the date so I can mark everything down so that you knew exactly what day and what time you had to be here.
Okay, sir. I'll be there.
What day do you want, Bioshi?
Your Honor, we can literally do this time next week, the 24th.
If you need a little bit more, because I know how busy you are, I'm happy to give you an extra week if you want.
Then that would be the 30th.
Yeah, but don't pick a Friday, because Fridays are busiest with arraignment. So perhaps like a Thursday or whatnot,
Okay, I'll pick, okay,
You want that Thursday?
let me just double check that.
That would be
Thursday, the 30th.
30th. You want to do that? And because of how great you have been, Bioshi, but
I appreciate you.
Yeah.
Yeah, Thursday, the 30th works.
all right.
Thank you. If you could,
You must be here January 30th. If the case is still active and it doesn't get dismissed, you must be here in person on that day and either accept the plea bargain from the state, or we will immediately set it for trial. Do you understand?
Yes, sir. Thank you.
All right.
This case is a reminder that every charge must actually make sense. Justice isn't about assumptions. It's about facts.